If you're watching this video, you may be interested to start your petition for a green card immigration benefit in the United States. In this video, I'm going to talk about interview guidelines that are used by the USCIS before being granted a green card benefit. What to expect in an interview appointment for adjustment of status. All adjustment of status applicants must be interviewed by an officer unless the interview is waived by USCIS. The decision to waive the interview should be made on a case-by-case basis. When determining whether to waive an interview, an officer must consider all relevant evidence in the applicant's record. The following list includes, but is not limited to, categories of cases where an USCIS officer may decide to waive an interview. Applicants who are clearly ineligible, unmarried children under 21 years of age of US citizens if they filed a Form I-485 on their own or filed a Form I-485 together with their family's adjustment applications, and every applicant in that family is eligible for an interview waiver. Parents of US citizens, unmarried children under 14 years of age of lawful permanent residents if they filed a Form I-485 on their own, or filed a Form I-485 together with their family's adjustment applications, and every applicant in that family is eligible for an interview waiver. Military personnel petitioners. USCIS may waive the personal appearance of the military spouse petitioner. However, the adjustment applicant must appear for an interview. USCIS makes every effort to reschedule these cases so that both the petitioner and adjustment applicant can attend the interview before deployment. The adjustment applicant may choose to proceed while the petitioner is abroad. Incarcerated petitioner. In these situations, the adjustment applicant must appear for an interview. An officer must take all the facts and evidence surrounding each case into consideration on a case-by-case basis when deciding whether to waive the U.S. citizen spouse petitioner's appearance. Illness or incapacitation. An officer may encounter instances in which it may be appropriate to waive the personal appearance of an applicant or petitioner due to illness or incapacitation. In all such instances, an officer must obtain supervisory approval to waive the interview. USCIS will notify the applicant of the date, time, and location of any required for the interview. You may find the date and time at the bottom of the notice. If USCIS requires an individual to appear for an interview but the person does not appear, the benefit request will be considered abandoned and denied unless by the appointment time USCIS has received a change of address or rescheduling request that the agency concludes warrants excusing the failure to appear. If an emergency such as your own illness or close relatives' hospitalization prevents you from appearing, the applicant must call the USCIS at the number shown here as soon as possible. The applicant can call this number if he or she has any questions related to the notice. The purpose of this interview is to verify important information about the applicant before determining the applicant's eligibility for adjustment or green card. For family-based applications, USCIS generally requires the Form I-130 petitioner to appear for the interview with the principal adjustment of the status applicant. In addition, if the applicant's derivatives are linked with this petition, they may also be required to appear regardless of the filing category. USCIS will let you know in your notice who should come with you. It's important for the applicant to bring all the documents or items mentioned in your notice. During the interview, the USCIS officer verifies that the applicant understood the questions on the application and provides the applicant with an opportunity to revise any answers completed incorrectly or that have changed since filling the application. Any unanswered questions or incomplete answers on the application will be resolved at the interview. If information is added or revised, the applicant should resign and date the application at the conclusion of the interview. If the applicant is not fluent in English and may require the use of an interpreter for the adjustment interview, at the adjustment interview, the interpreter should present his or her valid government-issued identity document, and complete an interpreter's oath and privacy release statement, and translate what the officer and the applicant say word for word to the best of his or her ability without adding the interpreter's own option, commentary, or answer. In general, a disinterested party should be used as the interpreter. An officer may exercise discretion, however, to allow a friend or relative of the applicant to act as an interpreter. If the officer is fluent in the applicant's preferred language, the officer may conduct the examination in that language without the use of an interpreter. At the end of the interview, you will be notified about the approval or any other adjustication if UCIS determines the need for this. UCIS will only send original notices and documents evidencing lawful status based on the approval of a benefit request directly to the applicant or petitioner if the applicant or petitioner is not represented. UCIS may send secure identification documents such as a permanent resident card or employment authorization document only to the applicant or self-petitioner unless the applicant or self-petitioner specifically consents to have his or her secure identification document sent to a designated agent, their attorney or accredited representative, or record as specified on the form instructions. We hope this information helps, and let us know if you need some help in your process of filling your visa or adjustment of status. If you have any other questions about this topic, do not hesitate to leave them in the comment section. You can contact us on Instagram, WhatsApp, Facebook, or directly on our website. My Visa Zoom, Immigration Forms Specialist.